Start. This court has thus held that whereas strong suspicion may not take the place of the proof at the trial stage, yet it may be sufficient for the satisfaction of the trial judge in order to frame a charge against the accused, full stop, para 13 dot. In a subsequent decision, that is, comma, in Union of India versus Praful Kumar Samath, comma, this court, after adverting to the conditions enumerated in section 227 of the code and other decisions of this court, comma, enunciated the following principles, colon, para, that the judge, while considering the question of framing the charges under section 227 of the code, has the undoubted power to sift the and weigh the evidence for the limited purpose of finding out whether or not a prima facie case against the accused has been made out, full stop, para 2 dot, where the materials placed before the court disclose grave suspicion against the accused which has not been properly explained, the court will be fully justified in framing a charge and proceeding with the trial, full stop, para 3 dot. The test to determine a prima facie case would naturally depend upon the facts of each case, and it is difficult to lay down a rule of universal application, full stop. By and large, however, if two views are equally possible and the judge is satisfied that the evidence produced before him, while giving rise to some suspicion but not grave suspicion against the accused, full stop, he will be fully within his right to discharge the accused, full stop, para 4 dot, that in exercising his jurisdiction under section 227 of the code, the judge, which under the present code is a senior and experienced court, cannot act merely as a post office or a mouthpiece of the prosecution, comma, but has to consider the broad probabilities of the case, comma, the total effect of the evidence and the documents produced before the court, comma, any basic infirmities appearing in the case, and so on, full stop. This, however, does not mean that the judge should make a roving inquiry into the pros and cons of the matter and weigh the evidence as if he was conducting a trial, full stop, para 14 dot. The scope and ambit of section 227 was again considered in Niranjan Singh K.S. Punjabi versus Jitendra Bhimraj Vijay, comma, this court held that, colon, 6 dot, can he marshal the evidence found on the record of the case and in the documents placed before him, as he would do on the conclusion of the evidence adduced by the prosecution after the charge is framed, question mark. It is obvious that since he is at the stage of deciding whether or not there exists sufficient grounds for framing the charge, comma, his inquiry must necessarily be limited to deciding if the facts emerging from the record and documents constitute the offense with which the accused is charged, full stop. At that stage, he may sift the evidence for that limited purpose, but he is not required to marshal the evidence with a view to separating the grain from the chaff, full stop. All that he is called upon to consider is whether there is sufficient ground to frame the charge, and for this limited purpose he must weigh the material on record as well as the documents relied on by the prosecution, full stop, over. दोस्तों एक जगह यहाँ पे आया हुआ है टू डिसाइडिंग, है ना, ध्यान दीजिएगा, अभी हमें मिल नहीं रहा है, तो यहाँ डिसाइडिंग नहीं होगा, टू के बाद वर्ब की फर्स्ट फॉर्म लगेगी, इसीलिए यहाँ डिसाइड होगा, ये शायद मिसप्रिंट हो गया है। ठीक है, थैंक यू।